कैसे होगा emphasizes progress, harmony and development. For the last 116 years, Phd Cci has been serving the nation. Phd Cci reaches out to 150,000 companies with focus on the development of large, medium and small businesses. Phd Cci has co-opted national and international industry associations and organizations through over 151 global MOUs and more than 60 domestic MOUs. With access to governments and international forums, Phd Cci ensures that the voice of our members is heard by those who make decisions that ultimately affect their bottom line. The mission of the Phd Cci is to provide a proactive leadership role by providing quality services, to act as a catalyst for rapid economic development and prosperity through promotion of trade, industry and services, to strengthen technological advancement through effective industry-government research partnership, to emphasize productivity, improve work ethos and encourage business ethics, to effectively project credibility and commitment of business to the society at large. To support its members, the Chamber has expert committees, state committees and task force. Phd Cci brings together intense research, ideation and advocacy to support businesses. They support the members proactively through intense research and advocacies. Not only members, they also support the government in formulating prominent policies that support economic growth. With this, the Chamber brings out a unique opportunity to network nationally and internationally. Phd at its headquarters in Delhi and its regional offices at Chandigarh, Jaipur and Lucknow provides unique facilities for conferences and business networking events to its members. The prominent services of the Phd Cci are ideation and research on topical issues through expert committees and task forces, advisory services to business on corporate affairs, taxation, finance, capital markets, etc. Certification services for origin of goods for exporters and other documents, capacity development through trainings and workshops, interface services with central and state governments, corporate social responsibility through voluntary organization. So, an association with Phd Cci would add value to your business. Phd Cci offers memberships under the categories Patron, Star, Ordinary, Association and Professional. Benefits to Patron and Star members: get opportunities to be part of the Managing Committee, may get opportunity to be the Chair or Co-Chair of various committees, opportunity to be a delegation member to meet government and statutory bodies, get branding and publicity, to avail the facilities of the library and business lounge of the Phd Chamber. The Patron members and Star members will have their logos displayed on the Phd website and Phd Bulletin. Additionally, special discounts to members availing Phd Cci's infrastructure facilities. For more details, please visit our website www.phdcci.in. We welcome you to join Phd Cci, be a part of the golden story of more than a century, and be a part of the nation's growth.
Please join.
अच्छा, जो भी करना है उसको करो भाई, किसका करना है? हाँ आप बिल्कुल पूछो। नहीं, आप देख लो, जो भी आप ठीक समझते हो। एसजी से लेके मेरी बात कराओ, ठीक है? एसजी से एसजी, चल कोई बात नहीं, जब भी आएंगे आप दोनों फाइनल करके मेरे से फोन कर लेना। वी मस्ट फाइनलाइज टुडे, ठीक है? ओके, थैंक यू जी, थैंक यू।
Good afternoon, Multani ji. How are you?
Good afternoon ji, how are you, sir?
Very
All
good.
good?
Oh, everything is good. Hi, Sachit. How are you?
Good afternoon. How are you?
All good. Everything is fine. So all set. You're starting a vacation now with the High Court getting closed today.
So, we find avenues. Delhi is closed today. Bombay reopens on Monday. So we'll find an avenue there.
Okay.
Good.
The number you're calling is currently.
So I'm trying to get it.
Sachit, that is the spirit. क्योंकि यही उम्र है भैया, मेहनत करके खूब पैसे वगैरह कमा लो, ठीक है ना? Good, very nice, and good to see you.
How are you, sir?
All good, all good.
नमस्कार प्रेसिडेंट साहब, नमस्कार चेयरमैन साहब मुकुल बागला जी।
Namaskar, sir. So that the right time to earn right now, so that you can enjoy when you're Mr. Multani's age.
Yes, absolutely.
Looking at Mr. Multani's enthusiasm and efforts that he puts in, I don't think there is any age to relax.
Then I fully appreciate what you are saying, and that's a fact, because one is enjoying what one is doing.
Absolutely.
That is important, and plus I think in today's day and date, anyone who retires and sits at home, believe me, that is the end of his life. We have to keep ourselves busy and active. That is my. Kyunji, I'm sure your dad must be equally active in everything.
Yeah.
Am I right or wrong?
Touchwood, yeah, he is, and more with other social things than actual work. But yes, he keeps himself busy. Multani ji, we have Mr. Sanjeev Sharma. So here, welcome, sir.
Yeah, good afternoon, everyone. Whether you can hear me?
Good afternoon. Yes, sir, we can hear you. Good afternoon.
Okay, good afternoon.
Welcome, sir. Good afternoon, Pradeep Multani here. Welcome, sir.
Thank you very much. Thank you, Multani ji.
Good afternoon, sir.
Good afternoon.
Sir, how are you?
I'm fine, Sachit.
Good to see you after a long time.
Yeah, certainly. It's because now it's we are distance is because I'm in Patna, and because of this Vivek's program, Zoom, I could attend this meeting. Otherwise, it's very difficult to attend in person.
You're welcome, sir, and thanks for coming. And we have the other speakers also, Gaurav, Samir, and Gauri. So welcome to you as well.
Thank you. Hi, everyone.
Hey.
Hi, Gaurav. Hi. Multani ji, we have a totally young team today. We have a young president. We have a young chair and co-chair. Although Pallavi is a little unwell, but I'm sure she's going to join. And we have a galaxy of young speakers, Gaurav and Samir and Gauri, and Mr. Sharma, of course, is a stalwart, but again, I would say a young officer at the same time. So
absolutely wonderful. And the topics you choose are so appropriate and need of the hour for the full industry. Absolutely wonderful. Keep up the great work. Really appreciate it.
Thank you, sir.
So, with the permission of chair, can we start the program, sir?
I think 3:55. Hey, let's wait till 4.
That's 2-3 minutes. Okay, we will start sharply at 4. Yeah. Namaskar, Pallavi ji. Namaskar.
So, Sanjay ji, you are right now looking after investigation, is it?
Yes.
Oh, wonderful. Okay.
I look after the state of Bihar and Jharkhand.
Oh, wonderful.
Okay. So, Jharkhand must be really challenging for you at this time, I presume.
Yeah, I think what you said is correct.
Ji.
Multani ji, Sanjeev ji is in the investigation department right now, so he looks after all the searches and surveys.
Right, ji.
So he's looking after the two particular states that he's mentioning.
Right.
I must share, Multani ji, with you my first experience with Sanjeev ji. I was a young, enthusiastic lawyer who had just joined the profession in 2007.
Ji.
And I went to him. He was then the additional commissioner of income tax in the international tax wing.
Right.
And the kind of learning and rollicking I got from him, I haven't still forgotten. And
Wonderful.
then that has continued when he was here in the ITAT as the departmental representative. And we've had our, the amount that we get to learn from him, even though he's always on the opposite side, is phenomenal.
Wonderful. And
thank you, Sachin, for your kind words in the beginning. And I think you continue to have the same thing when we finish this seminar. And let us learn from each other. Yeah.
So we have Pallavi here. Hi, Pallavi. How are you?
Good afternoon, sir. Very well. How are you, sir?
You're looking absolutely fine. There's no way that we're letting you go. Pradeep ji, Pallavi is in. She's traveling right now, but she's kind of joined in from there.
Wonderful. Pallavi ji, good afternoon.
Namaskar, sir. Namaskar, Sanjeev, sir. How are you, ji?
Good afternoon. Good afternoon, Pallavi. How are you?
Very good, sir. How are you?
I'm fine.
Sir, to add Sachit's experience, mine is the same. I think mine was a little before Sachit. I had gone to serve for a TDS NOC under 195.2 in the old drum shape building. And I learned 195, I think, from him. He said, read this case, read this, and then come back. So, sir, thank you. We have really been enriched. I think in our early days, sir, you were you're a guiding light, who not only told us the yes and the no, but also the how to, which is very rare. Thank you, sir.
Thank you, Pallavi.
And sir, since you are such a wonderful human, one would love to meet you personally in Delhi. We look forward to meeting you at our chamber physically in one of these great days. I'm sure Pallavi and Mukulji and Sachit will request you to have a physical webinar with all our members in Delhi.
Yeah, truly my pleasure to be with all of you.
Thank you, sir. Thank you very much.
So we have about 100 plus registrations. So I'm sure people must be logging in and they must be expecting that probably we'll start 4 or 5 minutes late. But I think we should start by 4:01 or something like that.
Sure, sir.
Is Mr. Bhutani there?
Hi, good afternoon, everyone.
Yeah. Hi, Mr. Bhutani, how are you?
Very well. How are you? I can see a lot of familiar faces.
Good afternoon, Mukesh. How are
Sir,
you?
how are you? Hi,
I'm fine.
Sachit. Hi.
Hi, Mukesh. How are you?
Good.
Good afternoon, Mukesh, sir.
How are you?
Very good, sir. How are you?
Good.
So, Pradeep ji, we have Mr. Mukesh Bhutani. Mukesh ji, I am, by the way, Mukul Bagla. I chair the Direct Tax Committee here in PhD Chamber. So, I've met you before during Mrs. Anita Kapoor's regime when she had formed a committee on various TDS matters. So, I had the pleasure of meeting you there.
Yes, that's a standing committee. Yeah.
Yeah, that's standing committee, right. So, Pradeep ji, Mr. Bhutani is one of the stalwarts in the international tax regime and transfer pricing, of course. And he is the founder of BMR Advisors.
Thank you for your generosity.
So Pradeep ji is our president of the chamber. He is the chairman of he's the president of the PhD Chamber of Commerce, and he is the chairman of the Multani Group.
Miss Pradeep ji, how are you? Hi, Gauri, how are you?
Very well. How are you? I just have a very bad throat. So apologies in advance for my course voice, but lovely seeing you again.
So everyone on the screen are panelists, right? Or doing the introduction, right?
That's right. That's right, Mukesh.
I think we can start, Mukulji.
I think we can, because I think the people will keep on logging in. So, but I think everyone is having a tight schedule, and let's start.
Shall we start the program, Chairman, sir?
Yes, please do, sir. Please do.
Okay, thank you. A very good evening to all. On behalf of PhD Chamber of Commerce and Industry, we welcome you all for today's webinar on TDS Implications on Foreign Remittances, Changing Landscape, being organized by the Direct Access Committee of PhD Chamber of Commerce and Industry. And I would like to throw some light on the Direct Access Committee of the PhD Chamber, which is under the Shri Mukul Baglaji as a chair. So we represent the issues of the PhD Chamber related to the direct access to the Government of India, various departments of Government of India and the Department of Revenue, particularly for their consideration, so that ease of doing business becomes more and more prominent at the larger and at the mid-level and at the micro level also. So our objective is to percolate the ease of doing business from the central level to state and then to the district level, so that India is able to attain the trajectory of $5 trillion in the coming times. So today's program is in the same way is very prominent and will help for the more and more simplification of the taxation system. And I would like to mention that the challenges and complexities are compounded with the digital transactions and cross-border payments. The dynamic and evolving international jurisprudence on treaty entitlement adds an extra dimension for the taxpayers and professionals to juggle with the juggle while deciding on effective withholding tests. To decode the address all the above issues and many more, a webinar is organized on the foreign remittances changing landscape by the PhD Chamber of Commerce and Industry. So we look forward that there are more and more fruitful discussions, and there is a representation for the recommendations to be made to the Government of India for their consideration. So with these words, I would like to invite our President, Shri Phd Multani ji. He has more than 40 years of experience in the field of Ayurvedic and Unani medicine sector, and has been chairman of 81 years young multi-crore Ayurveda and Unani company for more than 30 years. Shri Pradeep Multani ji, please, for your presidential remarks.
Thank you very much, Dr. S.P. Sharma. A very good evening to all of you. Welcome to the webinar on TDS Implications on Foreign Remittances, Changing Landscape. We have eminent panelists with us here. Mr. Sanjeev Sharma, Principal Director, Investigation, Ministry of Finance, Government of India. Mr. Mukesh Bhutani, eminent tax lawyer, BMR Legal Advocates. Mr. Gaurav Mittal, Associate Partner, Tax, KPMG Assurance and Consulting Services LLP. Mr. Samir Gogia, Director, Tax, Deloitte. Mrs. Gauri Puri, Partner, Shardul Amarchand Mangaldas. Mr. Mukul Bagla, Chair, Direct Access Committee of Phd Cci. Mr. Sachit Jolly, Co-Chair, Direct Access Committee. Mrs. Palvi Gupta, Co-Chair, Direct Access Committee. Shri Saurabh Sanyal, Secretary General, PhD Chambers. Dr. S.P. Sharma, Chief Economist and DSG, PhD Chambers. Ladies and gentlemen, withholding tax or TDS provisions, as they are popularly called, were introduced as a wartime measure to essentially provide an indirect method of collecting tax, which combines the concepts of pay as you earn and collect as it is being earned. Its significance to the government lies in the fact that it prepones the collection of tax, ensures a regular source of revenue, provides for a greater reach and wider base for tax. At the same time, to the taxpayer, it distributes the incidence of tax and provides for a simple and convenient mode of payment. TDS on foreign remittances have always been a bone of contention between taxpayers and tax administration. It was therefore no surprise that Section 195, which regulates withholding tax on foreign remittance, became the cynosure of all eyes in the famous Vodafone tax dispute. However, TDS provisions in today's dynamic tax landscape not only act as a mode of revenue collection, but also reporting of transactions which would have otherwise escaped the tax net. TDS on e-commerce operators and TDS on crypto transactions are recent measures which have enlarged the tax net for the government. The challenges and complexities are compounded with digital transactions and cross-border payments. The interplay between TDS provisions and equalization levy, which will be discussed in detail today, is one such complexity. The dynamic and evolving international jurisprudence on treaty entitlement adds an extra dimension for the taxpayers and professionals to juggle with while deciding on effectuating withholding tax. The MLI and particularly the principal purpose test and its impact on existing tax treaties will also be discussed in the session today. Digitalization of the process of reporting and use of technology by the tax administration has its own share of complications. I am sure the panelists will discuss this aspect as well. Overall, the evolving tax landscape in the field of withholding tax is bound to keep taxpayers and tax administrators interested in the years to come and necessitate such webinars and brainstorming sessions. On this note, once again, I welcome all delegates and participants to today's webinar. Thank you, Jai Hind, and God bless us all.
Thank you, President Shri Pradeep Multani ji, for sparing your valuable time to participate in this very, very important program and your very effective inputs regarding the TDS implications on foreign remittances and the changing landscape of the taxation. So these are very, very vital for the PhD chamber, and we look forward to your continued support and guidance. Now, going forward, I would like to invite our theme presentation to the members and discuss implications of TDS on foreign remittances. And I would like to throw some introduction of the our chair. He's the chair of Direct Taxes Committee of PhD Chamber of Commerce and Industry, and he is vested with the experience of 20 years, and he has expertise in direct taxation work in respect of issues related to domestic taxation and international taxation. He's senior partner at OP Bagla and Company LLP, and he helps us in various representations to the Government of India on the various TDS issues which are put forward by the members of PhD Chamber of Commerce and Industry. And most of the representations by the Direct Taxes Committee are accepted by the respective departments of Government of India, and we are happy that we make effective representation to the Department of Revenue and concerned departments of the Ministry of Finance. Shri Mukul Bagla ji, please.
Thank you, Dr. Sharma, for the lovely introduction. And dear friends, I welcome you all to today's webinar on TDS implications on foreign remittances in the changing landscape. I thank Mr. Multani, our president, thank him for the time that he has paid for our program, and thank him for his very enlightening welcome address. I also welcome Mr. Sanjeev Sharma, Principal Director of Income Tax Investigation, someone who has worked extensively in the international taxation and the transfer pricing verticals of the Income Tax Department. Although his present designation is in the investigation department, but we all know that his expertise lies in international taxation, and also he has served as the commissioner in the advanced pricing agreements. I also welcome Mr. Mukesh Bhutani, who is an eminent tax lawyer and international tax expert. We all have seen him talk and learned a lot from him. He's again, as we mentioned earlier, he's the founder of the BMR Legal Advocates. Warm welcome to him. A warm welcome to all our other guest speakers, Mr. Gaurav from KPMG, Samir from Deloitte, Gauri from Shardula Merchant, and of course my co-chairs Sachit from DMD Advocates and Pallavi from SR Dinodi and Company. I welcome you all the participants who are attending this webinar in great numbers. Coming to the topic of today's webinar. So withholding tax on foreign remittance is a widely studied and extremely debated topic. A topic which brings in huge litigation and tax demands. The appeals which are related to withholding tax and other international tax matters consists of, I think, bulk of the pending litigation in ITAT and High Court matters. I think we have a lot of lawyers on the panel here today, and I'm sure they'll vouch for the same. In fact, the Delhi ITT itself has benches dedicated to the international tax and transfer pricing, and such benches have significant pendency and backlog. Every new judgment from High Court or Supreme Court has huge repercussions on the existing pending litigation. In the context of international taxation, the question is whether to withhold or not, and if to withhold at what rate is extremely complicated decision requiring deep knowledge of not only the Tax Act, but also of the double tax avoidance agreements, the multilateral instruments, the commentary of OECD, UN Model Tax Conventions, and the ever constantly evolving judicial position. I would say due to some conflicting decisions of the various courts, the taxpayer is under a dilemma whether to withhold or not. The matter is further complicated when the recipient of the payment refuses to bear the tax component, and the tax has to be borne by the remitter, as this has an adverse impact on his cash flows. With passage of time, as the law matures, one expects that the courts would settle disputes, and this would reduce litigation by bringing clarity to the issue. I think the foremost example of this is the recent decision of the Honorable Supreme Court in the case of Engineering Analysis Center of Excellence, where the Apex Court has settled a long-standing dispute on taxability of software licensing fee. But at the same time, we see that this is not normally always the case that this dispute or the old litigation is settled once and for all. Like recently, we have seen in the judgment of the Honorable Supreme Court in the case of Northern Operating System Private Limited, which has triggered a fresh debate on taxation of secondment arrangements. While this judgment is on the levy of service tax on secondment reimbursements, the observations of the court are expected to disrupt several judgments on income tax withholding side as well. Another intriguing aspect of international transaction is the applicability of the most favored nation, the MFN clause available in some tax treaties. This issue has several facets, and its applicability requires evaluation of not only the respective tax treaty, but also of the treaties which can trigger the MFN clause. There are several High Court decisions in this matter, including order of the Honorable Delhi High Court in Concentric Services, Netherlands. And recently, the CBT has also issued a circular clarifying the position of India as a nation on this particular issue. The dividend distribution tax has recently been abolished, and taxation of dividend in the hands of shareholders has found its place back in the Income Tax Act. While claiming treaty benefit for non-resident shareholders would open a plethora of issues, one interesting ongoing debate is regarding availability of treaty benefit to the dividend distribution tax deposited by Indian companies declaring dividends. Many tribunals had held that the rate of dividend distribution tax in respect of dividend paid to shareholders should not exceed the tax rate as per the respective DTAA. But recently, the Honorable ITT Mumbai, in the case of Total Oil India Private Limited, expressed doubts over the correctness of such decisions and has requested the president of the tribunal to constitute a special bench to give decision on the above. These are the more of the legal aspects, and of course we'll be touching many topics in the forthcoming discussions. But the international disputes, tax disputes, are not only limited to legal interpretation. Even tax compliance with foreign remittance has its own share of issues. For instance, claim of treaty benefits at the time of withholding requires the remitter to obtain his tax residency certificate from non-resident, and that too for the relevant period. So in practice, particularly during the COVID pandemic, we have seen that it was not so easy to obtain. Thus, an issue arises whether treaty benefit can be given in the absence of the relevant TRC of the non-resident. The Honorable emblem ITD in the landmark case of SCAPS Industries Private Limited has held that TRC is not the only document to enable the deductor to apply benefit of tax treaties. I think we have a question on this which will be taken up in detail later on. So most of these case laws will be discussed in detail later in the webinar. A few more things which I'd like to bring your attention to is the complication in respect of provision of section 206AA of the Income Tax Act, which require deduction of tax at a higher rate in case the non-resident does not have a PAN in India. So the section 206AA does give some concession to non-residents who do not have PAN, but still they need to obtain certain documents in details like the TIN number of the payee, the certificate of incorporation, etc., which may be a challenge in many cases. The consequences of non-deduction not only results in huge tax demands under section 201 of the Income Tax Act, but also results in disallowance of expenditure under section 40A(1) of the Act. And unlike 40A(IA) of the Act, which prescribes 30% disallowance in case of payment to residents without TDS, the entire expenditure is disallowed in case of payment to non-residents without TDS. So this is a double whammy to the remitter, as once the demand is raised after a gap of 2-3 years, he cannot recover the TDS amount from the non-resident. And at the same time, the expenditure claimed by him is disallowed in his income tax assessment, resulting in huge tax demands. The major challenge for both the tax managers and advisors is to keep themselves updated on the international tax judgments. And this is the basic purpose of today's webinar. The idea is to disseminate maximum knowledge for the benefit of all the delegates. We've kept a very simple format of this webinar and have given specific questions to the guest speakers. These questions are very relevant in day-to-day withholding decisions. Also, the delegates are requested to write their questions in the chat box, which shall be addressed by the speakers during the Q&A session. With this theme of the webinar, I expect the webinar to be extremely knowledge disseminating and useful to the delegates. And I hand it over to Sachit, my co-chair, who's also the convener of today's webinar, to take it forward, please.
Thank you, Mukulji. I think you've laid out the theme very well. We are looking at the legal aspects and compliance aspects of TDS issues when in the context of non-resident payments. At this juncture, I consider it my pleasure to invite, I won't call him my friend, but he's a senior and a mentor, Mukesh Bhutani, to give the keynote address. But before that, I must introduce him, because I look at him as probably Kapil Dev of our tax fraternity. He, whether it's policy advocacy, advisory, structuring, litigation, or great mentorship, I think Mukesh stands up as in all. And if you add that he also writes books and contributes to academia, I think Mukesh in that sense is an all-rounder in our tax fraternity, and somebody whom all of us look up to for his thoughts and guidance in these aspects. So Mukesh, without holding any more time, I think everybody wants to hear you, not me. So we look forward to your keynote address.
Thank you, Sachit. Thank you for your generous praise. And thanks to Pallavi and you for inviting me. Thank you, Mukul, and all the panelists and Honorable President of the PhD Chamber. I think what I intend doing is rather than stealing away the thrill of what your expert panel is going to talk about, share some of my experiences. So, in the first two address, quite a few cases were cited, GE Technology, engineering analysis, Vodafone. I just wanted to go back a little bit more, though I was born after the 1961 code came into effect, but for many, many years as a student, and when I was training as a chartered accountant, we often used to look at the 1922 Act and the cases that came out of it. So I just wanted to start with the historical perspective of Section 195, or the equivalent of Section 195 in the 1922 Act. And the first most significant case was this case of Anglo-India jute mills, which still often gets quoted. This was a decision of the Supreme Court arising out of the interpretation given by Calcutta High Court. And the question over here was, what does any other sum chargeable to tax mean? This, of course, came up for interpretation in 2010 by former Chief Justice, Justice Kapadia, in the GE technology case. But it's very interesting what this decision talked about. It said that this includes payments which are in reality not pure income profit, but are gross trading receipts. So this is really the first principle that got established. And for many, many years, up until the Transmission Corporation case came up, which became a subject matter of debate in 2010, when Justice Kapadia was examining the GE technology case. The Supreme Court in Transmission Corporation not just approved the Calcutta High Court decision in the Anglo-India jute mills case, but it also went ahead and observed that for such determination by the assessing officer, that sum which is not chargeable is also to be determined by the assessing officer by granting a certificate, or a certificate could be without deduction or at a lower deduction. This really was the issue that was a confirmed principle up until the time the GE India technology case came up, which arose out of the Karnataka High Court decision in Samsung's case. It's a different story that the Karnataka High Court did not examine treaty aspects, and both the jute case and the transmission case was not dealing with treaty aspects. But here, interestingly, the law officer, the additional solicitor general, then tried to present an argument that virtually every remittance to a non-resident should attract tax. And Justice Kapadia in those days said that, this sounds extremely absurd. And that's what led him to interpret the expression chargeable under the provisions of the Act. And he came to the conclusion that if something is not chargeable, where is the question of deduction of tax? Interestingly, this was in the context of royalty, which got decided in March 2021 in the engineering analysis case. And in those days, for some reason, the then Chief Justice was not interested in dealing with the merits of the royalty case. And we presented, interestingly, Mukul, you spoke about double whammy. We presented the theory of triple whammy before the Supreme Court. And you described the double whammy, which is denial of deduction, and the 201 demand that gets raised, which is fastened upon the taxpayer responsible for withholding tax. The triple whammy arose because in those days, at least the Bangalore jurisdiction of the tax department raised a demand on the non-resident, saying that it is liable to tax on the so-called royalty. It raised a demand on the Indian company under 201, saying that it is liable to withhold tax, and it also denied a deduction. That was the triple whammy theory, which finally got settled. Interestingly, Section 195, just the law, and I'm not talking about the enabling rules, I'm not talking about the CBDT circular, has been through a plethora of changes. One decision that gets often talked up until subsection 7 was introduced is the famous Calcutta High Court decision in the ABN AMRO case, where the Calcutta High Court said that the word chargeable is not to be taken as qualifying only the phrase any other sum, but it qualified the word interest as well. This decision was a very interesting decision, and it was alive for many, many years up until 197, 195.7 was inserted. Well, I'm not going to talk about engineering analysis because I know there would be many people who will debate engineering analysis, and we perhaps have not seen the final word on engineering analysis given the fact that the Union of India has filed for its review. I just wanted to touch a little bit on Vodafone. Vodafone was an interesting case. We know what eventually happened in Vodafone, but in the context of Section 195, it clearly held that that 195 did not apply because this income was not chargeable to tax because the capital asset was not located in India and they could not have been the charge of tax. But it also said that fasten tax liability on one non-resident making payment to another non-resident for a transfer of asset which is outside India. To some extent, this principle of Vodafone, which also got subsequently reversed in the 2012 amendment to the law, where it said that it doesn't matter what's the residential status. What is important is the chargeability of income. If income is chargeable, then withholding tax will apply. And the fact that the non-resident does not have a place of business in India is not relevant. But this principle, up until the time Vodafone got decided, was very clearly articulated by none other than Mr. Palkhiwala in his last written edition of book 1977, where he called this absurd that you can fasten a withholding tax liability under the Indian law on a non-resident for a transaction with another non-resident, even if that income is taxable in India. So people who followed Kanga and Palkhiwala would see that clearly coming out very well. Now, there have been many issues that have arisen over a period of time as to how the withholding tax provisions would apply. Clearly, over the years, the law has been amended with no other intent but to be able to track a particular transaction. And, related to 195 is how the law was amended in 2022 to bring a very interesting section called 194S for the purposes of tracking transfers of virtual digital assets. Now, as we know, this imposes a 1% withholding tax obligation. But what attracted really my attention on remittances was what the finance minister stated in her speech. She says, further, in order to capture the transaction details, I also propose to provide for TDS on payment made in relation to transfer of virtual digital assets. So our thinking and our mindset, purely from a tax policy perspective, has not changed. And particularly when it comes to payments to non-resident, we still continue to use what I call it as the TDS on foreign remittances as a potent weapon to be able to track the transactions. Interestingly, the Delhi High Court, while dealing with the withholding tax obligations on a transaction which was otherwise subjected to the equalization levy law, this was the famous Coursera decision, or rather it's an interim order where the department attempted to characterize the payments that were made as royalties or fees for technical services on ed tech, and 10% was recoverable. However, here in this case, the petitioner contended that it was liable to deduct tax at 2% because it was an equalization levy, and the equalization levy law clearly provided that such income should be excluded. The Delhi High Court ordered the department to pass a fresh reasoned order after taking into consideration the exemption that was available. So the controversies continue in my view. Interestingly, Mukul mentioned about the most favored nation treatment. This controversy, I'm not going to get into the controversy, but the Delhi High Court rightly so took a view that the withholding should apply at a lower rate of 5%, which was the MFN rate, and not at 10% that was prescribed under the treaty. The CBDT rushed into action, fearing that this will result in a clutch of orders, and restrained now the field officers with what I view as CBDT's interpretation of the most favored nation clause, which in my view is a misplaced interpretation. And it's only the Supreme Court, it seems, that will finally decide the controversy. But to me, it seems that after a clutch of rulings on the most favored nation treatment, with Nestle as the lead case, the departmental officers would no longer be issuing the MFN benefit at the withholding level, because they would be now bound by the CBDT circulars. I just wanted to point out some of the other interesting, CBDT guidances in the past, which have played an instrumental role in shaping up of the law for withholding tax, particularly Section 195 and 193. And some of the important circulars that caught my attention was this circular of 1983 that clarified that deduction has to be on a gross amount and not on net of taxes. This was nothing but reaffirmation of the Calcutta High Court decision under the 1922 Act. What also appeared interesting was a circular of 1974, and in this circular, again, some of the decisions of Transmission Corporation were affirmed. This is circular number 152, where it said that the person responsible for paying to a non-resident has to consider the whole amount which would not be chargeable to tax, and cannot make a pro rata determination. The pro rata determination, if any, has to be made by the assessing officer only through a certificate under 195(2), which I think was really the case that the taxpayer was putting forth in 2010 in the GE technology and the batch of appeals that got decided. Another very interesting circular of the board, which in my view, department did not consistently follow, and they went ahead and amended the law, was the payment to foreign suppliers towards what was in those days called the systems software along with the hardware. Immediately around the time when India was opening up for economic reforms way back in 1991, there was a circular that was issued which said that a taxpayer which is engaged in the business of export of software for computer application and imports any systems software along with the hardware, the lump sum paid to the foreign supplier for acquisition. And interestingly, in those days, they used the word acquisition of any right in relation thereto or for use of such right will not be liable to tax. In my view, the department erred in violating its own circular of 1991 when they held a view in the context of royalty that this is liable for, this is to be characterized as royalty, the software payment. Of course, subsequently they went and retrospectively amended the law in 2012, but it seemed that they breached their own circular of 1991, which clearly provided. Other circulars that were issued in the context of shipping income, many other circulars, remittances to countries where DTAA is in force. 1995 was the first time when it was held that if there is any remittance to a country in which a DTAA is in force, the tax should be deducted at the rate provided in the Finance Act or the rate provided in the DTAA. Now, interestingly, this 1995 circular is clearly overridden with the 2022 circular on the most favored nation treatment, because the 1995 circular on remittances to countries with which DTAA is in force is still in vogue, but so is the 2022 circular in the context of most favored nation treatment. So you have two contrarian circulars. One circular that says, look at the DTAA rate or domestic rate, whichever is more beneficial. Here, clearly, the MFN rate is more beneficial, but that is being denied. This circular was further fortified in the context of dividends and capital gains under India-Mauritius Treaty, not once, but twice. Circular 789, which became the famous Azadi Bachao Andolan case. And after the Azadi Bachao Andolan case was decided, Circular 1 of 2003, again of February 2003, where the 5% and 15% withholding tax rates on dividends and royalties were re-emphasized. Again, there was another re-emphasis in the context of payments made by foreign portfolio investors as well. So you see, I'm not going to speak any further. Suffice for me to say that it's very intriguing to read this circular and practice this circular, at least almost 3.5 decades of my career, and I'm sure it's going to keep me more interested for the rest of my work life as well. But I leave it to the expert panel to decipher and analyze this very interesting arm of law in our statute. Thank you, Sachit.
Thank you so much, Mukesh. And thank you for capturing 3.5 decades of your experience in 10 minutes. And I think that's the eloquence and clarity that you bring to the table. It's quite unbelievable. Thank you so much for sparing your time today. Now, moving on, I think just before we head into the panel discussion, I'll pick up from where Mukesh left on a couple of issues. And I think I wanted to share my thoughts on that. One, on the concept of the tax presence, as Mukesh elucidated, which the Vodafone decision and the late Palkiwala's book dealt with. I think it's extremely important that principle of tax presence is incorporated specifically in the statute to avoid any further litigation, or for that matter, to provide clarity. We have a circular in vogue in the context of Section 194J, where the CBDT has already clarified that if a foreign law firm if a foreign company is making payment to a law firm or a chartered accountant firm in India, that will not suffer a withholding tax because that foreign company has no presence in India. Of course, if it has a permanent establishment, it will have to withhold tax, even though it's not a person situated in India. But this question becomes extremely important in view of the new provisions which have been introduced, whether it's 194O in the context of the e-commerce operator, 194R or 194S, as Mukesh was talking about in the context of crypto transactions. Because if the withholding tax obligations are enforced on a person or a company which is not even situated in India or has no, as we call, taxable presence in India, then it leads to a very anomalous situation where you may keep raising the demands, but you'll never be able to recover. So I think one of the pragmatic views would be to to exclude them specifically, not just for the purpose of 194J, but for all other provisions, that if you do not have a presence in India in the form of a PE or other presence of a branch or an office, the withholding tax obligations should not be fastened on them. I think we have this aspect will be dealt with more elaborated in the panel discussion. The second, I think, most very interesting aspect which Mukesh highlighted was the triple whammy. Mukesh, if I add the equalization levy, now it's a quadruple whammy for the taxpayers. And considering the arrangement which has been made recently in the Google matter, where in the High Court, where the High Court said, look, you are subject to a tax of 10% if it's royalty or FTS. You're subject to a levy of 2% if it's EL. What you do is, since you've already deposited 2% as EL, deposit the 8% as royalty FTS. I mean, it's a makeshift arrangement, but look at the difficulty which a taxpayer has to now go through, and look at the difficulty for the payer. Now, if the payer doesn't deduct, he suffers a disallowance, he suffers a 201 consequence. And if the non-resident doesn't deposit EL, then he suffers penalty. And we know there is no appeal against an EL demand. It's only a penalty. So an appeal is only prescribed against an equalization penalty. So it's a catch-22 for the businessman today how to even plan their affairs. I think with those two broad thoughts, I'm going to now move to our panel discussions. We have a heavyweight of a panel, starting with none other than Shri Sanjeev Sharma, who's the Principal Director Investigation in the Bihar and Jharkhand region. But that's not for the reason why he's there. I think we have him because of his vast experience in the international tax circle, both as heading the APA program as a CIT APA, as I would say the foremost, which I remember as the Commissioner of Income Tax, International Taxation in the tribunal, where he used to be up against me almost on a daily basis. I said earlier, I learned a lot from him there. He's also worked as a tax policy advisor in the OECD for more than 3 years, and is also an expert in the programs of UNDP, OECD, World Bank, and IMF. He was actually named, and I think it's something we should be all proud of, as the tax official of the year 2021 in the Asia Pacific region by the International Tax Review. And he also contributes regularly. We keep seeing his updates on LinkedIn. So it's always a pleasure to have you. We also have other panelists. So we have Gauri Puri from Amarchand, Shardul Amarchand. She has a rich vein of experience in advising and structuring transactions. Gauri, it will also be good to see you in the litigation field sometime, probably in the court. We have Samir Gogia, Director Tax, Deloitte, and somebody who's I've often heard at webinars, and some of his elucidation on practical aspects of TDS has always left me spellbound. We also have Mr. Gaurav Mittal, Associate Partner Tax, KPMG Assurance and Consulting Services, LLP. I had the privilege of discussing some of the issues with Gaurav, and I found his thoughts very insightful in terms of how, at least in fact, planning this event. So we look forward to hearing all of you. I'm going to start with the lady in the house, Gauri. Gauri, over to you. I think everybody's touched upon this principal purpose test, which was introduced through MLI a couple of years back. And how has that, I mean, I'll leave the floor open to you. How has that pretty much changed the tax landscape as a deductor? Over to you, Gauri.
So good evening, everyone. And again, thank you, Sachit, for having me and giving me this opportunity to speak with all of you and PhD and all the esteemed panelists here. On your litigation comment, that's not going to happen soon. I'm very happy in my office, being on the other side of the fence. So yeah, on the interface of TDS and principal purposes test, I see this like as a broader question, to be honest, in terms of the interface of generally anti-abuse rules that have been introduced in the recent past, to address treaty shopping with TDS obligation. And I'll sort of deal with this question in two parts. So these anti-abuse rules could either be the limitation of benefits clause, which you often see in treaties. It's there in the India-Singapore tax treaty, it's there in the India-UAE tax treaty, where the essence is that if you have set up an entity which does not have any bona fide business purpose, only to claim treaty benefits, those benefits should not be allowed. You then have the principal purposes test, which was brought in by the multilateral instrument recently, which is now sort of globally recognized as a minimum standard of ensuring anti-abuse when it comes to treaty shopping, which essentially, if I have to put it very simply, says that if you've set up an entity for purely tax reasons, and there is really no commercial and economic substance there, then the treaty benefit should be denied. And then we also have general anti-avoidance rules, mind you, in our domestic tax laws, which override tax treaties. So even if there are certain treaties which do not incorporate the principal purposes test, like the India-US tax treaty, or do not have a limitation of benefits clause, you generally have the acts of the general anti-avoidance rules, which sit within our domestic law. And so really the issue is that in the last 10 years, right, there has been a major shift in both the practice as well as the law of treaties, both within India and globally. It's no longer enough that you set up an entity in a foreign jurisdiction with which our country may have a good treaty and claim a lower tax rate or deductions or refunds or deferrals. It's important that you're able to substantiate two things. The legal and beneficial ownership in the hands of the person who is receiving the income. And then the second is a commercial substance or an economic rationale, what we say a non-tax reason for setting up in that jurisdiction. The question is, how do you see that economic substance? What are the tests that you typically apply? And then their interface with TDS, which I'll come to in a bit. So when you're talking about economic substance, you're essentially seeing what are the non-tax reasons for setting up in that jurisdiction. Is there an office space? Are there employees? Do they have an independent board sitting there which is capable of taking decisions for that particular foreign entity? Are there any expenses in that jurisdiction? To what extent is that entity complying with generally the accounting and legal framework there? So you're looking for hard evidence to be able to substantiate to the Indian tax authorities that having regard to all the facts and circumstances in play, you are not there merely because it offers, let's say, a make available clause with the Indian tax treaty or a capital gains tax exemption or a low withholding tax rate. You're there because it makes sense for you to be set up there in the context of your business. And if you see the OECD commentaries on the principal purposes test, there are illustrations. For example, if a foreign entity wants to set up a manufacturing unit overseas to sell products into India, and it has options of setting up that manufacturing facility in 3 countries, A, B, and C has a tax treaty with India, and it elects to set up in C, does that mean that that was the principal purpose of its setup? And the answer is no, because it has economic substance there. There's a full-fledged manufacturing entity. So that would not be, a treaty abuse, as opposed to a situation where you just have a shell entity with nothing there, and that's trying to take, treaty benefit or treaty advantages. So this is the piece about, a taxpayer genuinely trying to understand for himself whether he would be entitled to tax treaty benefits. When you dollop this on, or you put this on to TDS obligations, right? The question is, how do you expect an Indian payer who is making a payment from India to do this diligence into your affairs and understand whether you are in fact meeting these, anti-abuse rules tests, you have commercial and economic substance, and how does business carry on as usual? Even presently, when you're extending treaty benefits, even if I don't go into these anti-abuse rules, there's a checklist, right? You take an OP declaration, you'll take a tax residency certificate, you'll take a Form 10F, you'll go on to take, a permanent account number, a permanent or a PAN substitute, or then you would always also want to see what is the characterization of income rate. So there are many hoops that you need to jump before you elect or you take on that risk of extending a treaty benefit to a non-resident payer. Now, on top of that, there is this nuanced exercise, this subjective determination of whether or not the person that you are making payment to is meeting the test set out in the anti-abuse rules. So I think if you ask me, I would deal again from a TDS standpoint, because I feel there is nothing more practical in the income tax code than TDS, because nobody wants to take another sardard onto themselves. So how do you deal with this? How do you carry on with business as usual? If it is an intra-group transaction, then obviously it's a different ballgame, because then the group as a whole is absorbing the risk of the Indian entity not withholding tax, and it has the information or the wherewithal to make a sound judgment call as to whether or not treaty benefits should be given. But if it's a third-party transaction, right, what do you do? Because you do not have the information or the knowledge or the bandwidth that for each and every non-resident that you're importing goods and services, you will go into their economic substance, their story and their history, and then take a call. I think the way we would advise clients on this is that there are a bunch of, ways in a hierarchy that you should deal with this. Of course, like I feel the way any Indian tax authority would recommend, TDS is a provisional deduction. You must deduct taxes. If you're in doubt, they can always file their tax return and take a refund. Unfortunately, in most of these third-party situations, especially where you have Indian entities importing technology, which is very expensive, or in fact, even taking foreign debt, they do not have the negotiation power to tell a non-resident, guess what, I'm going to withhold your tax. and you can take you can file a return and claim a refund. I've seen it in my career very, very rarely. So that's a practical option.
Yes, ma'am, because we have a lot of questions to follow this.
Sure.
We have about 15 questions to be answered, and of course the Q&A after that. So please be a little brief.
Sure. Certainly. So that could be one way. And then the second option would be, okay, you do not withhold tax, but you go and apply for a withholding tax order, which is again something which is often cited by the revenue, right? That itself often takes 1 to 2 months. And mostly you will see, again, if you are an Indian entity which does not have negotiation power, you will see the foreign entity pushing back on this. Simply because the general sense in the market is that favorable withholding tax orders that give complete relief, which a foreign enterprise feels it's legitimately entitled to, are not coming forward. So they don't want to go down that path. So ultimately what you're left with is an indemnity, which is an after the fact protection. Because then even in case there is a tax demand against you, you have to go after the non-resident to be able to, sort of claim your money back or claim your losses and damages back. So it does impact business in the ordinary course. Is business moving on? Yes, but to expect a third party Indian payer to go into so much depth of their, vendors sitting overseas and understand whether they are entitled to treaty benefits or not is definitely a cumbersome exercise. No two questions about that.
Thank you, Gauri. I think this is not the last we've heard on the principal purpose test. And, one tidbit on this was, while I was researching initially, I found that the principal purpose test has always been part of the India-UK treaty and also part of US domestic law right from, tax treaty network was set up in the US. So the US and UK have always looked at the principal purpose test before applying the treaty. Now, moving on to the most interesting topic, I think this is probably the most hotly debated topic right now in the Indian tax landscape in the context of withholding tax, is the applicability of the most favored nation clause in the context of withholding tax. And we, I think both Mukulji and Mukesh referred to it in the context of the Concentrix decision and the subsequent CBDT circular. And, I think none better than Mr. Sanjeev Sharma to throw light on that aspect. And, knowing him, I know that he'll give a holistic perspective on it. Over to you, sir. Look forward to your thoughts on it.
Thank you, Sachit. I thank Phd Cci, its leadership and organizers for inviting me to this panel. And to begin with, I say that whatever I say, that is in my individual capacity and should not be taken the views of the CBDT or the tax administration on any issue. Regarding MFN, certainly that Mukesh has touched upon this, and it is also touched upon by Sachit. This is an issue which has come to light or highlighted after the provisions of the dividend taxation came into law again, starting 1st April 2020. And this came to further highlight with the decisions of the Honorable Delhi High Court in the case of Concentrix and Optum Global Solutions. So I would just say the background of MFN very short, and what happens when the negotiation of a tax treaty takes place. Because all who are attending this, they know the decision and all. I will not be enriching them as far as the decision is concerned. So MFN, this has most favored nation clause, is having roots in the General Agreement on Tariffs and Trade. That was in 1947 after the World War II. And then when it is a revised, means new version of WTO in 1995. This MFN along with the national treatment, that is means this is just to create level playing field and this equal treatment, or I should say that no discrimination in the trade dealings with anyone. If you give a favorable treatment to someone, then you are obliged to give that treatment to everyone. That is the most favored nation clause. What happens that because India taxes most of its income based on the source taxation. Like we have fee for technical services. That is not this article or this taxation as a source taxation is not in the developed countries. Similarly, royalties taxable only in the resident state. If we see the Article 12 of OECD model, there is no taxation right to source state at all. And that is mostly with the developed countries. Same with the dividend and interest, those are generally taxed in the residence country. What happens when the India comes for the negotiation of its tax treaties with the developed countries? Then they say, let us come for a medium-term solution or a solution which is acceptable to both. So the source taxation rights are given to India or to other developing countries as per the UN model, what we all know. What happens that when the negotiations take place, then the country generally, because what this MFN clause was, most of the Western European countries, not the East European, which were earlier, or we can say Canada, then US or Mexico, here Japan, Korea, these were the OECD countries, including Australia. But most of those were concentrated in the Europe. So what happens that when someone comes for negotiation, they say you have royalties, FTS, interest, dividend. If you have a source taxation, then source taxation should be same for all the countries. You should not give any favorable treatment to one country. Let us say that if France comes for negotiation and you have a favorable treatment to, let us say, to Portugal or to Austria, then the investors, instead of investing from the France, they will invest from those countries, or the investors from the France, they will not be having the level playing field. So at the time of negotiations, the France will insist that whatever tax treatment you are giving to investors from my countries for dividend or for anything, then that should not be less favorable than what you give to others. So that is the things where at the time of negotiation, India, let us say, agreed, okay, that whatever rate we are giving to you or you are accepting, we promise you that whenever we give a more favorable rate to any other country or a scope of taxation, means definition of that particular item of income is less restricted in other case, then certainly we will give to you. And that is the background. So with this background, and generally this is the OECD countries, this MFN clause has been agreed by the India, mostly with the OECD countries, because those were the developed countries which were interested that it should be a level playing field for everyone. So keeping this in mind, that everything, because not much litigation was there till we have the issue with the dividend, because the dividends are quite large, the quantity is quite huge, and if the tax rate is 10% or 5% or 15%, then the amount also becomes more. And it is also important that, particularly with the dividend, that might be that the residence country may not be taxing that dividend because of the participation exemption or for other reason, because some countries even exempt the taxation of dividend. So if tax rate in India is high, not 5%, but 10%, so it's a tax cost to the investor, and the investor certainly doesn't want that tax cost. Keeping all these facts in mind, that was the reason that when the issue of these two cases, or might be other cases, when they came to the assessing officer applied his mind by saying, because at the background, because tax administration, as I said, that we have the background that at the time we entered treaty with you, with the country, let us say Netherlands, whatever OECD countries were at that point of time, you had the best rate or whatever the best scope of what we had given to others. Okay, so keeping that, because in the High Court decision, what happened? The taxpayer argued that there have been some treaties like with Slovenia, Lithuania, or Colombia, which were entered into, of course, certainly a very means in 2005, 2012, or 2014, but these are now the OECD countries as of now. Because they have a less tax rate, which agreed by India, so India should also give to Netherlands the same tax rate. So if we look into, because why? Because even Mukesh touched on this issue, but I think all of us need to keep in mind that when the tax treaty was entered into with Netherlands, what were the other OECD countries, what rate we were giving to them? Okay, and let us say in 2005, 2012 or 14, when we gave a less rate to Slovenia, Lithuania, or Colombia, certainly nobody would have thought that this will become an OECD country. Or the Slovenia, Lithuania, which were part of the East Bloc, that East European countries, and those were developing countries at that point of time. That's the reason India thought that, okay, 5% rate is fine for giving to them. Now they're becoming an OECD country later on, and then France or Netherlands or Switzerland coming out with the clarification or decrees that because India entered into a tax treaty with Slovenia and tax rate is 5%, and this will be the tax rate. I think this was one of the factor or basis which was also considered by the Honorable High Court. So summarizing the whole thing, I'm of the view certainly on the not much on the notification, but certainly on the being the third country of which tax treaty for the MFN clause is being used, that has to be member of the OECD at that point of time. I think that we need to keep this in mind and try to look into this decision from that view. Because if, let us say, today, Malaysia, we don't have a FTS clause. We don't have FTS clause with UAE. We don't have FTS clause with other countries. Suppose these countries become OECD member now, whether it will happen that all OECD countries which are having MFN clause, FTS clause will not apply at all. Let us, yeah. So this is the point I wanted to raise. And as far as the withholding tax is concerned, because this is certainly withholding tax is because of the taxability, as happened in these two cases. Certainly, the payer, which is the Indian subsidiary of the foreign group, they did not apply 195(2) application, or they did not made the tax deduction on their own. That's the reason the foreign company applied for 197. So my advice would be that wherever the huge tax are involved, or where a lot of interpretations are involved, then as a deductor, the decision should not be taken. The decision should be left on the deductee to apply for 197 and whatever tax rate is there. But I agree with Gauri that because they may not be having a very competitive position on negotiating very high position, that the Indian company passing on the tax burden to the foreign company. They may be saying that I want the net of tax payment and the tax burden will be on Indian company. So all these issues certainly will be between the payer and payee. But my advice, as I said, would be that to go in such cases for 197 and not for 195. Thank you, Sachit. I think this is...
Thank you, sir. Gaurav, can I now quickly have you give the taxpayers' perspective on it? I think we've heard the revenues perspective. Maybe you can shed some aspects on practically on how does it pan out when you actually go and file your TDS returns.
Yeah, thanks, Sachit. So I think Sir has fairly covered the perspective, because the issue has been decided by the High Court, and High Court has decided in favor of the taxpayer, and they have taken a position that membership of OECD needs to be seen at the point of time when you are making the remittance. So, and as Sir mentioned that the concept of MFN is provide a level playing field, and when there are two OECD members and the benefit is provided to one of those, and this needs to be extended to the existing treaty member. I think that's the counter arguments that are there and available with the Assessee, and the issue would finally be settled by the Supreme Court. And even Department Revenue Circular also says that they'll enter into negotiation with those countries and find a way out. But I think till that is done and settled, this issue will remain alive and one of the contentious issues from a taxpayer perspective.
Right. In fact, I did a little bit of research on this, and I think it'll be useful going forward. India signed the treaty with Slovenia in 2005. Like Mr. Sharma rightly said, it was signed much later. But Slovenia applied for membership of OECD in March 1996. So when the India-Slovenia treaty was being negotiated, it was common and public knowledge that it will become an OECD nation. Now, one of the arguments from a taxpayer perspective could always be, and I'm just throwing out for discussion, that look, India always knew that in Slovenia will become a OECD member in 2005 or 2007 when later it became, then why give such preferential rate under the dividend article? Because that will then automatically be read into the Netherlands treaty. And I think that's some food for thought for both taxpayers and tax administration to look at. But I guess that's enough for the MFN. I think let's also look for the Supreme Court to give some guidance. Moving on to the next question, Gaurav. I think this is something Mukulji touched upon. That is TRC. In fact, the department always contends that TRC is not conclusive to give treaty benefit, and there must be something more. Now the question is slightly reversed. Can you claim treaty benefits even in the absence of a TRC? And particularly, I saw one of the questions in the chat box related to this. Is there a mechanism in India to get a TRC? And because if it is not, or in some countries there is not, how does one claim treaty benefits? Gaurav, to you.
Yeah. So I think, Sachin, the question of TRC is not new, because a taxpayer, a non-resident who's have to claim a treaty benefit, he needs to prove his residency. So a resident of a foreign country who has a treaty with India can claim the benefit of the treaty. So the question is, how do you demonstrate? And this has been a historical issue. When Indian Revenue started investigating Mauritian investments, and the CBDT came out with Circular 789 in 2000, almost 20 years back, that certificate of residence issued by Mauritian authority will be sufficient. Probably that's when we started looking at the TRC as an evidence for residency. But this issue was always there. And with Circular 789, because Mauritius was, there were a lot of investments coming in from Mauritius. So that circular kind of prevented that dispute from coming up. However, in 2012, Income Tax Act was amended and Section 90 subsection 4 was introduced, where the requirement of TRC was mandated for claiming a treaty benefit. And in the memorandum, it was written that the certificate is a necessary but not a sufficient evidence for claiming the treaty benefit. I think that's where the whole dispute started. And then there was also another aspect that the TRC should be containing particulars as may be prescribed, which was then withdrawn in 2013 Finance Act. However, this dispute and this concern of sufficiency of TRC was bothering taxpayers, and CBDT issued a press release on 1st March 2013. While they were elucidating on 90 subsection 5, they made a statement that TRC will be accepted as evidence of residence and Indian tax authorities would not go behind the TRC. So I think to that extent, when we look at Mauritius, definitely there is a circular, and in other cases also, while the memorandum of 94 said it is necessary but not sufficient, but I think the CBDT press release laid to rest, at least for the time being, that Income Tax Department will not really question your TRC and ask you to demonstrate your tax residency even if you have a TRC. Now, coming to the question where you don't have a TRC. So you might have situations where, especially in the COVID pandemic time, a lot of cases, people were finding it difficult to obtain TRCs from the foreign revenue officials. So this issue came up before Ahmedabad Tribunal in the case of SCAPS Industries. And it's a very detailed and very well-written judgment. And the question was whether Section 90 subsection 4, which mandates production of TRC, is overriding Section 90 subsection 2, which means, because in India, the well-accepted principle is treaties have superiority over the Indian Income Tax Act, and which is embodied in Section 90 subsection 2. So there was this conflict between two subsections of Section 90, which is Section 90 subsection 2 and 94, where the Ahmedabad Tribunal analyzed and held that treaty superiority continues, and even if you don't have a TRC, it does not takes away the benefit of treaty. But the tribunal did not stop there. What they further held is that, okay, you don't have a TRC, but you still need to prove your residency. And they said actually the ability to prove residency defaults of TRC is even more onerous. Because if you have a TRC, it's a single document that you bring to the payer and to the tax official, then you are done. But if you don't have TRC, then it's an open board where you'll have to produce your registrations, you have to produce your returns. You don't know what all documents will satisfy the person across the table. So actually not having TRC is actually a more onerous situation as opposed to having a TRC. But having a TRC is not a necessity, as has been held by Ahmedabad Tribunal, which has also referred to a AR of Sarko BPO, which was affirmed by Punjab and Haryana High Court as well. Thereafter, there are a couple of Hyderabad Tribunal judgments, and interestingly, one of the judgments in case of Srinivasa Reddy, the tribunal said that there is an impossibility of performance. The taxpayer tried, he did not get a TRC. And if he did not get a TRC, you can't force him to get it. So that's an interesting argument. I don't know how correct it is, but they read that they said it's an impossibility of performance. And to that extent, section 94 needs to be relaxed. So this is right now the situation is in the whole spectrum of ability to claim a treaty benefit without a TRC. But if you ask me, the right way to go about is to have a TRC, because if you don't have a TRC, department will certainly come back and say, okay, you still prove your residency, which will become a more difficult task.
Thank you, Gaurav. That was interesting. I always believe that the test to be satisfied is residency, right? You rightly said. A certificate only confirms that you are a resident. If you can show that by contemporaneous evidence, that should suffice. Now, moving on, I think Samir.
1 second, Sachit, would you want to, Gaurav, would you want to comment on the TRC to be obtained in India for an Indian resident? That was one of the questions I think which Sachit was referring to. Would you like to?
Yeah, I think there is a defined process and a form for that. If an Indian resident wants to obtain a treaty benefit for a remittance coming into India and they want to obtain that TRC to be given to the foreign jurisdiction payer, there's a defined form under the Act where rules which can be furnished with the officials and obtain a TRC in India.
Just to add to that, it's called Form 10FA, and this which is to be applied before your local AO, and he gives the certificate in Form 10FB. So I think that probably helps in that in that question.
Yeah, thanks, Mukulji. Arvindji, I hope your questions answered. Now I think Samir's been quiet, and moving on to him, Samir. Everybody is talking about crypto, NFTs, metaverse. Some thoughts on the TDS provisions, particularly on the acquisition, sale, and relocation of digital assets. I think we have some jurisprudence coming very soon from the CBDT, but your initial thoughts on how does the provision work and what are the issues on the acquisition, sale, and relocation of virtual digital assets?
Thanks, Sachit. Thanks, Sachit, for the generous comment you made while introducing me. And good evening to all the panelists and all my fellow panelists and dignitaries. Now, when you talk about virtual digital assets, I think that's the new bird that's been created this year. And the main contention was they wanted to tap the Bitcoin and the other transaction happening in the domain. The main purpose is to track those taxes and taxes on. Now, particularly coming to your issue, or what are the open issues with regard to virtual digital assets, which might be a bone of contention for a future litigation. If I quickly touch upon the definition, it talks about the limb 1 of the transaction, and the VDA have been defined under section 247A. It talks about the cryptocurrencies or payments tokens. It talks about any information or code or number of tokens not being Indian or foreign currency, generated through cryptographic means or otherwise. So I'll touch upon why I'm stressing on other or otherwise, may create issues by whatever name called, providing a digital representation of value exchange with or without consideration, with a promise or representation having inherent value. Now, the limb 2 of the definition talks about a non-fungible token or any other token of similar nature by whatever name called. So, and limb 3 talks about the other digital assets, which means that digital assets which the central government may notify in the official gazette specifically. So if we talk about the definition, it is really vast. It talks about the NFTs and the cryptocurrency right now, but government is open to introduce other forms as well. And there is a lot of open issues regarding that what all items such as vouchers or the credit card reward points or the airlines mileage, will those be covered under VDA? Now, my initial thoughts, and these are all my personal thoughts, what I feel that when it talked about trading on these cryptocurrencies, airlines mileage or credit card reward point, these are actually not traded on a exchange. So these might not be covered under cryptocurrencies. However, if you talk about cryptocurrencies being, do we think that this cryptocurrency is now being legal or the Bitcoin being legal? If we talk about that, Bitcoin is treated as a legal tender in El Salvador. So do we talk, it talks about a foreign currency. So does Bitcoin becomes a foreign currency because it's a legal tender in El Salvador? Again, food for thought for everyone to consider. This might be the litigation or issues which will be coming up as we unfold over the years. Coming to your question, and how does the exchange of VDAs on an exchange, how does the transfer happen? So if it specifically talks about, there is an issue with regard to the valuation of VDAs as well. How do we actually value VDA? So there is an issue on what amount the TDS need to be deducted. If it is being exchanged at two different exchanges, do we need to deduct it as the total amount, or do we need to deduct it at only on the notional gain? These, however, this section also talks about 1% TDS on the transaction. However, it also talks about that in case of a conflict or any other, if any other section get triggered, this section will override. So we are also seeing an interplay of this section with 194.0, which also talks about any other or transaction on sale or purchase on an e-commerce platform. So if considering this, if talk about your thing on an exchange value, I think if we take a particular example, in case the payment is made in kind or exchange or another VDA, or cash is insufficient, the seller has to make sure that 1% TDS is deducted or recovered. So I think that's the specific provision of the Act. However, if we talk about open issues, there are few of them. And I think if you have certain questions in the chat box, or if you think there's something, I'll be happy to take that, because it's something which is still evolving and will take some controversy in the future.
Thank you, Samir. On crypto, I personally have a lot of questions, but due to paucity of time, I'll park that and have a separate chat with you because we have another few very interesting topics coming ahead. Next to you, Gauri, on digital transactions like online advertisements, subscriptions, web hosting, cloud computing, etc., and its interplay with the equalization levy. We've recently read, like I was saying earlier, in the context of Google, where you have an interim arrangement where 8% deposited as TDS on royalty FTS and the balance 2 as EL. What are the issues that you are saying? I saw one where the taxpayer was in a quandary having deposited EL as a foreign company, and then the deductor having asked to pay another 8%. But I'm sure there'll be lots more. Your thoughts on that?
Sure. So I think this area, when it comes to, payments for digital goods and services, or you say online ad space, the key issue has been characterization disputes, and they all stem from India's reservation to the OECD's rights-based approach. India from the very beginning has maintained that, look, we don't believe in this distinction between copyrighted versus copyright article. We feel that as long as the payment is going from the Indian market for any technology under the head of license, that there should be withholding in India, irrespective of what are the rights that the user is getting. Even in a situation where the user has no control over the equipment, or has no possession of the equipment, or is not able to commercially exploit, the position has been, look, this is royalties, you should be withholding taxes. Another challenge here is because most of these digital goods and services are automated digital services, there's never really a human element involved. So to classify them under the head fee for technical services has also been very challenging for the Indian tax office generally. Now, that in 2012, we amended our definition of royalties, and it sort of diluted all these distinctions, such that if I was to only look at the domestic law definition, one could argue that payments for, web hosting services or online ad revenue, etc., could possibly come within the definition of royalties. But then the treaty definition never changed, and that brings us back to the case of, the engineering services case I was talking about, the Supreme Court decision, which has, sort of upheld now that, look, the treaty provisions remain unchanged. You cannot read the domestic law definition of royalty into these, treaties that are essentially, so to say, a model on the OECD approach, which follows the rights-based approach. So from that perspective, I think there is general comfort in the market to a certain extent after the engineering analysis case that, look, on all of these kind of payments, like whether it's for online ad revenue or whether it is for web hosting services, cloud services, there should not be withholding under, royalties or fee for technical services. Having said that, right, I think there is always that one odd case. You have the Google AdWords case, for instance, where, the unique facts were relied upon in that case to essentially say, yeah, while we understand that an ad reseller agreement doesn't give rise to royalties, but look, Google India is also rendering other services to Google Island, where if you club these both, the IP that it gets in those other agreements, it's using for, that targeted advertisement. And so for that, payment should be qualified as royalty. So if you ask me as a practitioner, am I going to give a clean chit to anybody who asks me this question? No, you're going to say, look, even after the engineering analysis case, that was in the context of copyrighted article, your issue doesn't relate with that, so there is this issue. But yes, there is more comfort. On the interface of equalization levy, I think the government, if you see the 2016 report that Mr. Akhilesh Ranjan had headed that committee, it recognized that there's this wedge with OECD and they need to do something about it. Otherwise, they won't be able to tax and there will be characterization disputes. So after that, it's very clear that 2% EL on any goods and services offered digitally by e-commerce operators, which is paid by the foreign company. And then you have the 6% EL, which is on the online ad revenue. Now, the issue is that when in 2021, the government clarified that, yes, there is going to be between the two supremacy is with the withholding tax provision, it's a high rate. And so if it qualifies as a royalty or as an FTS, you should be withholding tax and EL will not apply. So while the government sort of went on to clarify that, there are no provisions under the equalization levy laws which allow for a refund or a set off. I mean, those teething issues, of trying to sort of ramp up what else should be done in these provisions to allow or give taxpayers relief if at any moment in time there is a reassessment proceeding or, a tax officer gets up and says, look, I think that was royalty FTS, that is not there. And that leads to those instances that you have been citing, whether it was Sumo Logic or whether it was the Google case, what do I do? And so you have to approach the courts because there is no mechanism under the Tax Act, whether by way of an interim order or, the Google case where said, okay, acha, you deposit the 8%, deposit the delta. Or even in MasterCard, where the AR held that they have a P in India because of that Microsoft MasterCard interface processor. They've gone and taken a stay from the court saying that if while you hold I have a P, I don't deposit equalization levy, I don't want this issue coming up. I mean, courts granted that. So I think the courts have been kind, but it would be helpful to see the government, sort of sort out these teething issues within the statute itself.
Thanks, Gauri. I would like, if Mr. Sanjeev Sharma, sir, if you would want to, I have a live case which, actually brings out the quandaries of a taxpayer. And if you would want to give your thoughts on this, there is a company which remitted payments from India. It withheld tax, treating it as royalty FTS. The foreign company believed it is not royalty FTS. It filed a return claiming refund. Now, in between, equalization levy comes in. This is a year-on-year problem. Now, while the foreign company has filed a refund claim in its return, it comes within the equalization levy bracket. So, on one hand, tax from its payments has been deducted in line with the government, which is not refunded. On the other hand, an equalization levy is in place. Now, what does the taxpayer do? Does it deposit 10 plus 2? Or does it wait for the refund from the government to come and then deposit the 2%? Because surely the government doesn't want 12% tax. It can either be 10 or 2. So what does the taxpayer do in such a situation?
Yeah, as Gauri said, I think that you need to wait for the decisions only, because till the mechanism is developed by because see, equalization was the new levy introduced, which is other than the tax. Okay. And the whatever provisions of royalties are totally different from this one. Certainly, this interaction is a practical issue. As far as you said, the taxpayer is burdened with the liability under the two types of taxes. And certainly, these are the issues which you need to bring in to the notice of the CBDT. And certainly, there is such type of thing that some clarification or something need to be done. In the meantime, might be the part-time set-off. If you have already paid more, and this is less, till a refund is granted or till that the 10% is confirmed in the courts, then you will not be 2%. Okay, if 10% is confirmed, there will not be 2%. If 2% is there, then there is no 10%. So might be set-off, and all these are the practical issues, and certainly that those need to be solved. Yeah, thank you.
Thank you, sir. Thank you for your thoughts. Moving on, Samir, to you now. Gauri alluded to I think everybody's alluded to the engineering analysis case. And it's back to square one with the review petition being pending in the Supreme Court. Coming to two very specific questions on the TDS on software payments. Does it make a difference whether the software is customized or available off the shelf? And secondly, what is the role, let's say, of a source code? If a source code is even provided to the recipient of the software, but he has no right to reverse engineer or modify the source code, does it make it royalty? Two specific questions, your thoughts on that?
Yeah, thanks, Sachin. I think the first question about being customized. Now, if I read it through, there were four issues before the Supreme Court on which it has commented. Two relating to the distributors, one relating to the end user, and one was the component of hardware, where the software is an integral part of the hardware. However, the Supreme Court did not commented on software being an integral part of the hardware. And I think that Section 9 actually will cover that, because there's an old circular, I think Mukesh also talked about this, that old circular talks about when there is a software which is an integral part of the hardware, it is treated as a good and you have a custom duty levied on this. So I think if we talk about this Supreme Court judgment of engineering analysis, they have covered all the four types. Coming to your question on a customized software, and if I talk about this judgment in detail, there has been a deliberate or detailed discussion with regard to various laws in this case, and specifically to the Copyright Act, where there is a customization and there has been no giving away of the right by the author or the starter of the product. I don't feel that this would get covered under royalty until and unless there is a right which has been transferred from the author to the end user. However, this need to be seen because Supreme Court has not commented on the customized software per se. And what they have affirmed is that at the stage of TDS, you can interpret DTA, and you see that DTA has a more deliberate and a much easier definition of royalty and FTS as compared to the Act. So you can have a benefit of DTA during the TDS provision while applying TDS provision. It has categorically distincted between copyrighted article and copyright per se. So I think that need to be taken into account, and it has affirmed the position. However, it talked about that it has been already pending for review. So we'll see how it unfolds. But ultimately, a customized software, till the time you are not dispensing of with any of your right as an author or a starter, will not fall into royalty. Now, coming to your second question, if you can just repeat the second question.
Yeah, it was on the as part of the software, the source code is also shared only for the purposes of integration, without any right to modification or reverse engineering. Will that qualify as royalty?
See, again, we need to see it. There are 2-3 things at the second level. One is assignment of right. The other is infringement. If that person who have the source code has a right to produce X number of copies, and he has been assigned those right to exploit that source code and do X number of copies, this again will not fall under royalty. However, if you talk about infringement or that source code being changed and entire rights being transferred from the author to the person who has been assigned this right, then only it will get covered into royalty. So if you talk about this particular judgment, or if this detailed judgment, if you go through this judgment, there is a detailed discussion on copyright, because that's where the crux of all the matter had lied, because there has been conflicting judgment on this issue. But if you go deep dive on this judgment, this has deliberated and detailed what a copyright article and copyright will be. And based on those facts, the decision need to be taken by the taxpayer. So I don't feel where on a source code also, this need to be seen on the facts basis, what all rights have been transferred from a author to the person who is exploiting it.
Thank you, Samir.
Sachit, I may add one thing. Sorry to interrupt you. We need to finish all the questions. So I would request that we do an answer in about 3 to 4 minutes maximum per question, because we still have 5-6 questions left, and then we'll have some time for the questions of the audience who have very kindly sent their questions also. So I would request everyone to just take 3-4 minutes, please.
Sure. Thank you, Mukulji, for being the headmaster here. Now to you, Mr. Sharma. I think one of the topics which has been talked about again and again is this TDS on dividend to foreign shareholders. We've discussed in the context of the MFN clause, but I believe it's not just the MFN clause, it's also about the source of the dividend being from the Indian company. And there are different classes of dividend which are classified under Indian law as dividend, which may not qualify as dividend under the tax treaties. So what are the issues that you see? And I would request Samir and Gauri to also then pitch in on what are the issues that they are seeing in the TDS on dividend to foreign shareholders post the abolition of dividend distribution tax.
Yeah, thank you, Sachit. This dividend taxation, as I said, as a classical system, has been again reintroduced from 1/4/2020, and DDT has been replaced. So Section 914 provides for the source taxation of this dividend if dividend payment is by Indian company which is outside India. So the corresponding taxation is mostly in Article 10 of the tax treaties. And the article provides that this dividend is taxable in the hands of the payee. That is, the primary taxation rights is to the residence state. But the treaty also provides that the source country is also having taxation right, and that we discussed in the context of the MFN clause. But MFN is a secondary thing which came primary to us. I think the most important issue is that this taxation right to the source state is as per the law of the country, let us say as per the Income Tax Act, but the tax rate will be less or but were restricted to 10% to 5% if the recipient is the beneficial owner of the dividend. I think this is the issue which is likely to be a very, very important and major issue. If the investments are coming from the countries or from the entities which were just the pass-through entities, or the those were just the intermediary holding company somewhere else, or the money was given by someone else and has been invested to those countries. So this beneficial ownership is going to be a very important issue, and for the tax administration as such. And there have been various decisions in the context of interest, that what will be who are the beneficial owners of the interest when the payments are being made by the Indian resident. But there are decisions, multiple decisions of the foreign courts on the beneficial ownership of the dividend. And the sum and substance of those decisions is that what the substance of that investment, if the entity which has made the investment, if that has the control and the user right of that money which is being received as a dividend, then that can be considered as a beneficial owner. Certainly, it will depend on the facts and circumstance of the case. If the money invested which has come in, let us say, to the Indian company, to the Indian subsidiary, that had immediately come in from someone else, let us say that the money is flowing from the countries which is having a favorable tax rate to that country from some other country where the tax rate is high. So whether this is an issue of the TT shopping, which will come into play. So this is beneficial ownership is a anti-abuse provision inbuilt in the tax treaties. And I think the tax administration, certainly they are on it and they will be looking into this issue. And for this, I consider is another important point other than the definitions of the various payments which will qualify to be the dividends. And certainly that will be the issue. But as per se, what we call dividend in the Indian law, that is the main issue, will be the beneficial ownership. Thank you, Sachin.
Thank you, sir. Samir, over to you. Any thoughts?
Yes, I think if we talk about dividend and after this change, whenever the basic question is giving a treaty benefit at the time of withholding stage. So that's been one of the contention, because if now with MLI being signed and a lot of things being changed, for a normal person to evaluate that the other person will be allowed or will get a treaty benefit is again a detailed analysis. Either he has to depend upon the experts to analyze, because while giving a treaty benefit at the time of withholding, you need to analyze who is the beneficial owner ultimately, what is the impact of GAR, domestic GAR, and what is the impact of MLI. And also, if we talk about this withholding at the time of TDS at the time of withholding, you also need to see if you can give a foreign tax credits. You have various ATM deduction being given. So you also need to analyze that. Can you give a foreign tax credit at the time of giving ATM deduction? Interplay of FTC and ATM. That's again play a major role, because ultimately the purpose of ATM was to avoid the cascading effect, which actually has not happened, because FTC in the hands of the company receiving dividend from an overseas entity has not been granted. So we also see a ATM cascading effect not being done up right away. Also, there's a deduction with regard to interest of 20%. Now, what is the timing? It has to be given before giving ATM or after giving ATM will determine the taxability. So if you see, there are a lot of issues which surround withholding at the time of giving treaty benefit. So is it right to give a treaty benefit when a person is withholding the tax to a foreign resident, or he should deduct 20% and then claim a refund? So this definitely remain an issue to be detailed, and I think most of the people will rely on expert opinion what the other person will be eligible for a treaty or not. So these are certain issues which are actually coming up while we are analyzing these withholding payments to non-residents.
Thank you, Samir. Gauri, any expert opinion on the issues that Samir has raised? Do you have an answer?
I know. I think that the points that Sir, the points that Sir makes, I think they're the most pertinent ones. And like Samir highlighted, it is going to be, especially for widely held companies, a very uphill task to extend treaty benefits to shareholders.
Thank you. To sum up, I think what Samir said, when you remit dividend, you look at PPT, beneficial ownership, GAR, and by the end of it, you decide to withhold because you can't satisfy all three.
And now, such as this, including this minimum holding period also. Now the benefit will be granted only when 365 days holding is there, minimum that one. So MLI amending the provisions.
So apart from a lawyer, you should be also a good mathematician to add up the days. Thank you, sir. Moving to you, Gaurav, something very close to everybody's heart and pocket. TCS on foreign remittances. If I buy something on Amazon US, do I need to collect tax at source? What do I do?
Yeah. So see, TCS on foreign remittances was introduced in 2020 by the Finance Act 20. And it covers basically two categories. So the first is when you're making a payment under liberalized remittance scheme, which is LRS. And under LRS, you can make payments up to $250,000. And they have specified purposes and for which you can make the remittance. You can make remittance for maintenance of family, gifts, foreign investments, immigration, medical treatment, studies, and so forth. So TCS would apply when you're making a remittance for under the LRS scheme. And how it operates is the banker, the AD banker, when he would remit on your behalf, he will be the one who will be collecting the TCS. There is another category which was introduced was when you're making payment for foreign tours. So if you're planning a foreign tour, so when you're making payment for that, there is a TCS applicability. And the TCS rate is 5% in case of both LRS and foreign tours. The only difference is in case of LRS, there's an exemption up to 7 lakh rupees. So if you're making payment under LRS for up to 7 lakh rupees, there is no TCS. The moment you cross that threshold within a financial year, the amount exceeding 7 lakh rupees, there is a TCS applicability. So if you see the rationale, I read a report which said that there is almost $60 billion which has gone out in LRS till 2020 when the provision was introduced. And there's some statistics that when department surveyed almost 5,000 companies who did the 5,000 remittances, so they found almost 1,500 did not even file their tax returns. So probably there is a basis from a tax department perspective to introduce this TCS. But if you look at, see, TDS and TCS provisions were basically linked to income earning process or a revenue expenses. But here what's happening is you are making a capital remittance. So maybe you are investing, but you have to pay TCS out of your pocket. The party will collect, the bank will collect. You need not necessarily, that payment need not necessarily be out of your income for that year. So you have savings which are there for past 20 years, and out of that you make a remittance, and the department insists on 5% TCS. So somebody making payment of, let's say, 1 crore of rupees. So he'll suffer a TCS on this, and he'll have to claim a credit in his tax return, while the person may not have income sufficient enough to claim that TCS. And there is no correlation between income for that relevant year and the TCS being collected. So it's not really in the course of business that TCS is getting collected. So it's a standalone transaction. Probably the government realized that there are cases where remittances are being made and they're not able to track and control taxation of people making those remittances. So there is a disconnect in the provision. Plus, one benefit they've extended in this is when you make remittance for education out of a loan. There, the TCS rate is reduced from 5 to 0.5%. So that's broadly the scope of TCS. couple of important aspects is apart from TCS, there are two provisions which also apply in this situation. One is 206CC, where if you don't have a PAN, the TCS rate is doubled. So if you don't supply a PAN, the 5% rate goes to 10%. There's another provision where even if you have a PAN, but you have not filed your tax return, there again the rate will be doubled. So in a situation where you find that the person making remittance has not, initially when that provision was introduced, it was requirement that 2 years tax return ought not to have been filed for the rate to be doubled. But last year, this budget, it has been reduced to 1 year. So if the person making a remittance has not filed a tax return for the past year and time limit for filing the return has expired, the rate of TCS would be 10%, not 5%. So I think these are broadly the provisions which are there, and a 10% amount is fairly significant, especially in a situation of person, the return time has expired, probably a person may still file a belated return or so. So I think these are provisions, plus looking at the disconnect from the income earning of the person, I think it's an onerous liability which has been imposed on the taxpayer. So as of now, not much dispute around it, but yeah, definitely a hit to the pockets of person making remittance.
Thanks, Gaurav. In fact, I believe there is a larger constitutional question that whether TDS can at all be applied when there is no income. I think that's something which the courts will look at some point of time. Moving quickly, we have 3 more topics to cover. Sir, Mr. Sharma, TDS on export sales and commissions. This has been probably the oldest dispute I can think of, starting from R.D. Agarwal, going back to Ahmed Bhai, Umar Bhai. Where does the income accrue? Where is the source when you make the payment of export sales, and can you characterize this as FTS in any way to bring it within the ambit of withholding tax?
No, certainly, Sachit. This is one of the oldest issue, and for this we had, in fact, a similar circular 23 of 1969 dealing with the income accrual arising or deemed to accrue arise, that one. And because then this export commission, if we look into in a very simple sense, that if somebody is making export sales and there is a non-resident who provides services in connection with that sale, might be for procuring the order or ensuring the supplies are reaching in time or getting the collections made and all, that can be various type of services which are provided. But there have been issues not because of the 195 as such, the 201 order might be in some cases, but this is because of the non-allowability of the payments which have been made under section 40AI. The whole of the payment are disallowed, and this really becomes a very big burden to the taxpayer if that is held that this is taxable. So the issue is very clear, and it should be that if services are totally provided outside India and there is no connection, means there is no presence, physical presence of that person in India, let us say part presence in India and part presence outside India, then can be a case of business connection or can be a case of permanent establishment, or those payments getting connected to the permanent establishment, but that is a permanent establishment of the foreign company taxing over here. So there might be complexities if such type of issues are there. There's some part presence is in India. If there is no presence in India and the services are rendered totally outside India, remittances are also made outside, nothing is received on behalf of that person in India, then certainly there is no question of taxability as far as its business income is concerned. But you are very right that if those services are of the nature of technical services, let us say some products are being sold and the customers are being given technical presentation about the products, or that maintenance is being done by the technical people over there, then whether if those facts come to the knowledge of the assessing officer that is provided in the agreement, then whether part payment or full payment can be considered as a fee for technical services. That would be an issue, but it will be a facts-based issue. As far as the taxability, as I said, that the CBDT had issued a circular in that was a circular, very famous circular of 786 of 7th February 2000, which considered all these issues based on the circular which was issued in 1969. But this circular has been withdrawn in October 2009. So the field is really open to the assessing officer and for the taxpayer. But certainly based on the facts, I think we have moved far ahead than basic understanding that what is taxable or what is not taxable. But the issue of this fee for technical services remains. And let me tell you that from the tax administration perspective, sometimes what happens when the assessing officers are doing assessment and they're not very much conversant with the provisions that what is taxable in case of a non-resident in India, then they disallow, might be without having much information on the facts. They just disallow, and that becomes a issue for the taxpayer. So whenever such type of issue is raised, it will be good for the taxpayer to provide all the information, to provide some facts, which will help the assessing officer in the appeal later on to justify that this income was not taxable in India. I have just this to say. Thank you, Sachin.
Thank you, sir. Just on the withdrawal of circular, before I give a shout out to Samir and Gaurav, I believe, sir, the circular was withdrawn for a completely different context in the aftermath of the Morgan Stanley decision, where probably it was misrepresented or misinterpreted. But I think the principles, apart from the attribution principle in the old circular of 69 and 2000, according to me, still hold good and probably should be a guiding light.
Sachit, okay, I was part of this committee which decided that withdrawal of the circular. So certainly Morgan Stanley was not the issue. Issue was becoming this taxability of the offshore supplies and onshore supplies and all that. The decision of Ishikawa-jima, the way it was being interpreted, because that one of that limb of the circular was based on this power grid corporation type of contracts. Okay. And that was being used, or I should say misused, by the taxpayer in splitting the contracts in services, onshore, offshore. And that was because the courts used to take cognizance of the circular that the government itself had issued the circular. That's the reason we really wanted to break that connectivity to the circular. That's the reason it was withdrawn.
Thank you, sir. Thank you. I think that's illustrative of why the circular was withdrawn. Now, Samir, to you. 2 minutes shout out. My headmaster, Mr. Mukul Bagla, has been messaging me. This whole secondment arrangements now, in view of the recent Supreme Court decision, although in the context of service tax, does it require a relook, or do you think that the judgment is confined to the facts of its own and may not apply in the context of income tax?
No. I think, as I said, this need to be relooked. The reason you have a ruling in the service tax regime, northern operating. However, this has opened up a different Pandora box. Now the issue is that the taxpayer was treating the same as employment service. Indian company was deducting TDS on that. However, this was treated as a service or a manpower service contract. Now, if you talk about this per se, whether these services will get covered as a fees for technical services, that need to be relooked. Whether this secondment of employees will constitute a fixed fee or a service fee as well, because if you talk about secondment arrangement, these per se involve three issues. One is an exposure with regard to service fee, issues with regard to fixed base fee, or fees for technical services. And if you see this judgment talks about various clauses in the intercompany agreement, the markup being charged by the Indian company, and other things. However, there has been some gray areas where, if you talk about previous Supreme Court judgment or e-funds or other cases, where it has stated that if the secondment employees are engaged in a stewardship activities, such employees do not constitute a service fee. And if they have a full control and supervision with the host country, still their economic and legal employee get shifted. However, if you closely see this judgment, this has actually been pronounced on the basis of lien on foreign employment. Those employees were still under the payroll of the foreign company. their social security and benefits were being provided. So this has led to the fact that even if they don't perform their duty well, they can still go back to their home employment, or it's a global contract, they can be shifted to any other country where their services will be required. So this is little fact-specific judgment, and we need to see all these cases based on similar facts, where you have a pool of resources where they are good on services, and any group company require their services, they can be shifted there. So that was the parlance, and that was the rationale behind this Supreme Court ruling, which talks about that this is more of a service contract rather than a pure reimbursement or a secondment contract. So definitely this has opened up a Pandora box for direct taxes, and definitely good works coming up for all our professionals as well.
Thanks, Samir. Looking at the positive side. In fact, when you were speaking, I was thinking about, there are deputations and secondments in the ministry when, people from the ministry are seconded to missions abroad and they receive the salary back. Will that attract a service tax, and will the ministry bear the service tax? Interesting thoughts, because the salary is now borne by somebody else. But I think
Sachit, one thing, I think the issue here is not, see, even if on a reverse charge they are allowed for a refund, or even of a withholding, they can apply for a refund. So either which ways, if there is a withholding and there is no income element, there can be a refund mechanism. The only issue here is, even if on ministries they are being deputed, they'll ask them, because there is a case which talks about the all service tax will also be interpreted in the GST regime. They'll have a reverse charge mechanism, and then a refund mechanism. Okay. So it'll be revenue neutral, and this argument was not taken by the Supreme Court. They talked about that it is revenue neutral, even if you charge, they'll be eligible for a refund, but that was not taken.
Interesting. Thanks, Samir. Gaurav, to you next. I'll skip the question on the TDS on the salary to expats. I think that's born and run, and anyways we are late. Moving to the last question, since this came specially from our chamber, how to claim benefit in India of taxes withheld in foreign countries in case the assessee has business loss and no income during the year?
Thanks, Sachit. So I think this question, I'll start with a small illustration to set the context. So let's say foreign company has an income of 100 rupees from a foreign country. Indian company has an income of 100 rupees from a foreign country, on which a tax of 10 rupees is deducted there. So the question is whether Indian company can claim the TDS foreign tax credit of this 10 rupees in India. But what happened in the same year is the domestic business incurred a loss of 200 rupees. So net result in the same year is 100 rupees of income from outside had domestic loss of 100 to 200 rupees. So net, there is 100 rupees of loss in the Indian company. So there is no tax payable in the year one. However, in the year two, the domestic business gave an income of 200 rupees and there was a brought forward loss of 100. So there was a net income of 100 on which 30 rupees of taxes were paid. So if we see year one and year two, so domestic business incurred a loss of 200 in year one, profit of 200 in year two, there is a neutrality. And in looking at tax, in year one, there was no tax, and year two, there was a 30 rupees of tax. So what in essence happened is the foreign income of 100 rupees in the year one resulted in a tax of 30 rupees in the year two. So this was the whole premise and the basis on which this dispute started. So the taxpayer said that because when you look at foreign tax credit in India, so there are two ways a foreign tax credit can be claimed. One is when you have a treaty. So under Article 23, generally it is, you can claim a treaty benefit, tax credit in India. If you don't have a treaty, then under Section 91 of the Act. And wording varies a bit, but largely the context remains the same. And this dispute came up before Mumbai Tribunal in 2021 in the case of Bank of India. And Bank of India has significant, almost 165 crore of foreign tax credit from various branches outside of India. And on an overall basis, they had a tax loss in India, so there was no tax payable. So the assessee argued that, see, if you look at the tax incidence of the foreign income, it will happen because it reduces my loss during the year. And in the subsequent year, I might end up paying taxes on it, as I explained through the illustration. So to which the tribunal passed a very detailed order. And they said that, see, the requirement under Article 23 of the treaty is the income should be subjected to tax in India. And when we see subjected to tax, it's a more onerous condition. It's not like liable to tax, that, okay, this income is liable to tax. So there has to be actual tax outflow for the income to be subjected to tax, which is not happening in this case. Plus, they refer to several international commentaries and jurisprudence, and they said that you can't really claim a refund out of a foreign tax credit. So that's not permitted even internationally. And even on Section 91, the tribunal observed that even Section 91 required the income to be doubly taxed. And the FTC deduction in India is allowed from the tax paid in India. So on both fronts, the tribunal held that the requirement is a payment of tax. So unless there is a payment of tax in India, there is no ability to claim a refund out of it. However, on the aspect of double jeopardy, tribunal also observed that the assessee has taken this argument, but there is no certainty whether the assessee will turn profitable at some point of time and pay taxes out of this, whether these loss carry forward will be eligible. Let's say there is a limitation on the carry forward of loss. So whether it really translates into something, there is no certainty as of today. So when we are looking at foreign tax credit in the current year, so the ability to argue double jeopardy is not, there is no certainty, and based on uncertain situation, we can't really grant you a credit. Another aspect here is that there are situations where foreign tax credit can be carried forward in foreign jurisdictions. So this kind of situation is not available in Indian domestic law. So to that extent, availability of foreign tax credit in India in case of a loss and no tax payable seems to be difficult. The judgment is fairly detailed and comprehensive. Just another point to it is the taxpayer alternatively argued that I should be given a tax deduction of this foreign taxes as an expense. So the tribunal referred to a Bombay High Court judgment in the case of Reliance Infrastructure. And basis that, they said, okay, you can get a tax credit because the disallowance of tax under Section 48II is only limited to tax as per Section 243, which covers Indian tax. There was a couple of explanations inserted in Section 40I, but again, those explanations attract in a situation where FTC credit is available. So in a situation where FTC credit is not available, there is no restriction under the Income Tax Act for you to allow a tax deductibility. So to that extent, a relief was granted by the tribunal, and FTC credit was allowed as a deduction. So if we look at broadly the way situation stands today, getting credit is difficult, but assessee can still look at the ability to claim a tax deduction out of it.
Thanks, Gaurav's decision seems more on equity than on law, but we leave it if it benefits somebody. With that, we come to the end of the panel discussion. Now to Mukulji for the Q&A and the vote of thanks. Thank you.
Thank you, Sachit. Thanks a lot. We'll take because all the participants, they have posted few questions, and in all fairness to them, we should be answering them. So I'll take one question at a time, and I'll request the speakers to answer those. The first question is, if the remittance is made towards the cost for carrying out research and investigation activities to non-residents, non-profit organizations operating outside India, having no connection, control, management activity or business, etc. in India, would it be subjected to TDS under Section 195? So Gauri, would you like to take that, or somebody else?
Sure, I'm happy to answer that question. So first of all, we need to understand that just because the payment is going to a not-profit, it is not a not-profit for Indian tax purposes. So India will treat it like any other foreign organization. like under the Indian Income Tax Act, this may qualify as fee for technical services because these services will require a certain amount of expertise, and therefore withholding tax may apply. But you have to see the treaty. If there is a make available clause in the treaty, which sort of allows you to take benefit of the fact that there is no transfer of knowledge or know-how to the Indian entity, then you can take a position that there should not be any taxes withheld, subject of course to TRC, legal and beneficial ownership, all of that, which in your non-profit case ideally should be met.
Perfect. I totally agree with your answer, Gauri. Thanks. The next question is the requirement of filing 15C, 15CB in case of payment to non-resident through credit cards? If yes, what will be the proposed date of payment in 15C, 15CB, since payment would have already been made? Samir, would you want to take that? Or Gaurav for that matter?
Yeah, so this is a problematic issue. Because 15 CSEV generally are issued when the payment is going through a banking channel. So technically, if you read the law, there is a requirement of 15 CSEV compliance. It's a foreign remittance going outside of India. Practically, there are challenges because, so let's say you're making a remittance, so you're downloading some software. Softwares are now, the larger debate is gone because softwares get the benefit of engineering analysis. So, but if you're making credit card payments, so see, the bigger challenge comes when people actually structure the transaction to bypass 15 CSEB. So let's say there is a corporate who's procuring services. If they were to make remittance through a bank would insist on a 15 CSEB. And let's say a chartered accountant is not willing to give a nil rate and the person doesn't want to withhold taxes because there might be a grossing up requirement. So there have been instances where corporates have used this mechanism to bypass 15 CSEB requirement and make a payment through a credit card. I think in those situations, the exposure definitely remains of non-compliance. The other general situations where individuals are making payment, I think with engineering analysis, most of the cases will get covered, and practically the situation may not arise in most of the cases.
Just to add, for personal use, there are also exemptions. So if the government doesn't expect you for file 15 CSEB if an individual is filing. So this issue will only be relevant if it's a business making a payment.
I agree. The question arises only when you're claiming it as an expense in your P&L. So that is where I think the withholding tax issues would arise in this case. But yes, I agree with Gaurav's answer. I have a question for you, Samir, which I'm not able to understand. It says TDS applicability on transactions where only payment made from dollar account made from India, but the person is non-resident of India and work also performed outside India. So I think this talks about a non-resident who has a dollar account in India and he's making payment from that Indian dollar account to a non-resident for work also performed outside India.
Let's see the regulatory aspect first. I think a non-resident can have a dollar as well as a rupee account. So if he have a dollar account in India and he's paying to, now let's take the next limb. He's paying to a non-resident again outside India for
work performed outside India.
So I think if we're talking about this chain or the mode of payment, I don't think that's more relevant. If we need to see what is this payment being made and if that person have a taxability in India, I think that's where the question lies. The mode of payment again will be a regulatory issue, and we need to see that this the banks will be there to check up on the regulatory part. But if we talk about this payment, we need to be more clarity on what sort of work and for what this payment has been done. So I think that need to be seen.
Understood. Thanks. So one question for Sanjeev sir. Whether withholding tax is applicable on payment made to Netherlands-based analysis agency for testing of food product in Netherlands by Indian exporter?
Yeah, okay. So this question is based on facts, but certainly need to be seen that whether this testing services which are being provided, that will come into the definition of the fee for technical services. So might be more facts, more informed, but certainly looks like because if those are technical services, then might be covered by the fee for technical services. and then the tax is required to be withheld.
Correct. One last question, which I think would sum up today's webinar, is: does filing of return of income in India is mandatory for the assessees who claiming DTAA benefits? If yes, then any impact on resident remitter if beneficiary of remittance does not file the return of income? So, Gauri, would you want to take that?
No, so I think that yes, the answer is yes. If there is a non-resident who is claiming a treaty benefit, then technically the position that we take in the market is that you are required to file a tax return in India. Although there have been a few AR rulings which says if it's not chargeable to tax, you're not required. If the non-resident does not file a tax return in India, it does not affect you, but it's preferable that they do file a tax return in India, because if there has been a short withholding of taxes and they have filed that tax return and paid the remaining amount of tax, then you can be left off the hook under the exceptions to Section 201. So it's always useful to covenant them to have them file the return in India.
Okay. One last question for you, Gaurav. What if the foreign company is able to give TRC for the last year and not for the specific year in which the remittance is being made? Should the benefit of treaty be given considering the residency being proved for previous years? I'll give it to Gaurav and Samir. Both of you can probably.
So see, technically it's not sufficient. But again, there's a practical call needs to be taken. Especially, I've seen many cases in the COVID scenario. Even in the US service provider, they were finding it difficult to get a TRC for the relevant period. And where there is a continuing transaction, practically one can rely on the TRC available for fast year on a condition that as soon as the foreign service provider gets the TRC for the current year, will supply it. But unless you have that certainty and you rely on TRC for the last year, that's not sufficient proof of residence and grant of treaty benefit.
I'll agree partially with Gaurav. The reason being is on a withholding type, I definitely will suggest that there has to be withholding, because there are other disallowances attached to a withholding or TRC being not done, or a short deduction. So I think TRC definitely, what Gaurav said, will be required, and that's one of the mandate. And definitely on advising to a client, we'll definitely advise to deduct if he's not able to provide TRC, to deduct at the full rate, not to give the benefit. So that's because of the disallowances connected. And I think, Mukul, there is another issue or a question on virtual digital asset. Somebody has mentioned. I think you skipped, or
yeah, I skipped by purpose. Actually, it was because of the paucity of time. But you want to
yeah, I think the thrust of the question is on the taxability. Will the virtual digital asset or the situs of that asset will play a role? Well, definitely yes. There is a High Court ruling which talks about the location of an intangible asset. There is a UAB Pty Limited versus Union of India. There's a High Court case which talks about that it's a well-accepted principle according to which the situs of the owner of an intangible asset would be the closest approximation of the situs of an intangible asset. So the non-resident would obviously like to argue that the situs of my virtual digital asset is not, or it's outside India. However, if we talk about Section 5.2, it talks about income accruing or arising in India. And if that transaction has happened in Indian exchange, definitely this will be get taxed in India.
Okay. A final take from Sanjeev sir. Would you like to add on any of the questions or give your view of any of the points that we have already discussed?
No, regarding the TRC, because now the law requires that TRC need to be obtained. But if the amounts are large and the tax implications are huge, then the non-resident need to provide the TRC. And because if either they say the tax administration doesn't provide at all, or they have put the procedure in motion that we have requested to the tax authorities, and there is a last year TRC, or we have filed the tax returns and all that thing. So taxpayer need to justify the reasons for not able to provide it. I think that may be looked into by the tax administration while giving the benefit at the time of withholding. Otherwise, withholding tax benefit may not be there. Then the non-resident can file the tax return when the TRC is received by him and claim the benefit.
Okay, so Mr. Sanjeev has the final say because he is the man from the department. So, with this we conclude today's webinar, and I thank Mr. Sanjeev Sharma for sparing his valuable time and for his invaluable comments on various aspects of withholding tax on payment to non-residents. I thank Gauri and Samir and Gaurav for their hard work, for answering all our questions, clearing all the doubts, and we look forward to seeing you again in our forthcoming programs. Thanks, Sachit, for wonderfully comparing and moderating the entire session today, and thanks to you in a wonderful effort. And I would also like to thank Dr. Sharma and Mr. Mishra for all his efforts and for doing a successful webinar today. Thank you so much.
All your guidance, sir, and we look forward to your continued support and guidance to organize such meaningful discussions. Thank you, sir. Thank you so much.
Thank you so much. Thank you.
Mukul. Thank you, everyone.
Thank you, everyone.
Thank you, sir.
Thank you, sir.
Very much. Thank you, Sachit.
Thank you.